Good afternoon. Mr. Simpson, you were taking us to Sargason and you were going to take us through Mr. Justice McGarry's approach.
Yes, Lord, I'm obliged. So at page 1279 of the bundle, which is in 1279 at letter D, one can see that the question before Mr. Justice McGarry was essentially the same question as is before the present court. Whether the taxpayer had the whole of his interest in land is transferred to some other person. There's undoubtedly a conveyance of the fee simple and the creation of a trust, so that one side, Mr. Walton contended that the whole of the taxpayer's interest was transferred, even though a new interest, the leasehold, was thereupon granted to him. That's HMRC's position in the present case, of course. On the other hand, Mr. Potter puts his emphasis on what I may call before and after approach. Before, there was a beneficial ownership of the whole fee simple, and after beneficial ownership of a 40 years lease, a lesser interest, but was comprehended in the fee simple before the transaction took place. The next page, 1280, again at letter D, Mr. Justice McGarry identifies one question that arises in the present case, which is what I say is the question upon which HMRC's position depends, and that is whether it could be said that the taxpayer always had in him, as one of the constituent parts of his fee simple, a 40 years term, or at least the possibility of such a term being created, and that when the conveyance and leaseback took place, the term was merely a fragment of the fee simple that remained vested in the taxpayer. So it couldn't be said that the whole of the taxpayer's interest had been transferred. And in my submission, that's exactly the issue of Scots law that HMRC assumes to be, that it is not a fragment of ownership that is transferred back. However, Mr. Justice McGarry goes on at letter F to say generally that he's considered these points, but there are manifest disadvantages in attempting to resolve some of the fundamentals of law and equity in a case stated in the construction of a fiscal statute. And in my submission, that's applies equally to the present case. So here we're talking about the interpretation and application of a paragraph in the VAT provisions, and that decision ought not to rest on issues of Scots law, partly because they're uncertain, and partly because, of course, the intention of the draftsman is to apply these provisions in a similar or the same practical way throughout the three constituent jurisdictions. And the final point that Mr. Justice McGarry makes at letter G on the same page, 1280, is that the language of the section as a whole is not the language of, let me say, Key and Elphinstone. I suppose is a technical English property treatise. And so what it's drafted in is broader and more popular language, which invites a broader and less technical construction, is what Mr. Justice McGarry states. And at the bottom of that page, he identifies as one of the reasons the fact that I just mentioned, that one can assume there to be an intention that the provision will in practice apply in the same way in each of the three constituent jurisdictions. And then Mr. Justice McGarry's decision, page 1281, is indeed on the basis of a broader and less technical interpretation of the phrase transferred his whole interest, that that test had not been met, and so the farmer was entitled to continue to claim capital allowances after the gift into trust and lease back. So my submission as regards how to approach the wording of this provision, given its non-technical nature, is that one shouldn't look at technical issues such as what is the source of the particular right of use that a taxable person has following the sale and lease back transaction, or what is the mechanism by which the taxable person who starts with the right of ownership ends up with a lease giving exclusive possession and use for 30 years. Looks at the broader issue of whether, after the facts and circumstances under consideration, the taxable person retains an interest in the relevant premises, the care home.
So you're founding in effect on what Mr. Justice McGarry says between E and F on 1281.
Yes, my lord. Yes. Of course, just in that passage, Mr. Justice McGarry refers to the imaginary moment of time, the scintilla temporis that.
I don't think that's been argued now.
No, that was the point taken at the first-tier tribunal, but is no longer taken by HMRC.
No, but it's really the emphasis on the outcome.
Precisely, my lord.
Yes.
And turning to now the context, legislative context of provision, in my submission, that makes sense. Because the context of zero rating and the plain intention of this provision to protect the integrity of the zero rating conferred, in this case, in the appellant. What is important in that context is the outcome. And not the means by which the outcome is achieved. Part of the context, of course, includes paragraph 36, subparagraph 3, which operates where there's a change of use. Paragraph 36(2) doesn't require any change of use, just disposal of the entire interest. In the context of zero rating, one might ask, what's the point of that? Now, my submission is that the point is to protect the integrity of zero rating by making it subject to the ability of the recipient, the beneficiary of the zero rating, to ensure that the relevant property is being used for a relevant purpose. And that's simply what we set out at paragraph 47 of our written case. I submit that's because the beneficiaries, in this case the appellant's, ability to ensure how the premises are used, how the care home is used, is a close enough link between the zero rated transaction and the final consumer to justify the zero rating on the basis of the policy behind it. It's reduction in the cost of social care. And that reduction in cost is, of course, achieved by reducing the cost incurred by the appellant, the first recipient of the major grant of a care home, on the acquisition of the care home. Sorry, my lord.
Mr. Simpson, it's easy to think of examples of dispositions of something less than the entirety of P's interest that would not leave P with any real sense of control over the use made of the premises. But I think you're saying that nonetheless that is the purpose of subparagraph 2.
Yes, my lord. My submission that in a sense it's difficult to work out what the purpose of subparagraph 2 is.
Yeah, I agree.
If one thinks that a zero rating itself must depend on a closely defined policy reason giving a direct benefit to the final consumer, my submission is that that policy reason is met where the recipient of the zero rating is still able to control the use of the premises, even if that person doesn't use them itself for the purpose of a care home, for example.
But you wouldn't say, would you, that the applicability or otherwise of paragraph 2 in a sale or leaseback situation depended upon whether the leaseback contained a user covenant by the lessee? I suppose in that case the lessee remains in occupation of the premises, but put it the other way around, assuming that what was retained was the reversion and the premises were leased out so that P had not disposed of the whole of his interest, and they were leased out on terms that did not include a user covenant by the lessee. Would that disapply subparagraph? Would that trigger subparagraph 2?
No, my submission wouldn't trigger subparagraph 2, and that's because I suppose one first has to start with the wording. In those circumstances, then there's still certainly a significant part of the interest that the recipient of the zero-rated supply is retained by that recipient. And of course, if depending on the terms of lease, it might not be the case, for example, that that recipient can still require the lessee to use the premises as a care home. But as I understand it, the way at least the respondents approach it is that use by the recipient as a care home counts for the purpose of paragraph 36(3). So in those circumstances, it would remain possible if the care home ceases to be used as such, then 36(3) would be triggered. But in my submission, in no circumstances could looking at the purpose of 36(2) mean that provision is engaged where the fee simple or a right of ownership is continued to be held by the recipient of the zero rating. So my submission as regards purpose is really directed at how one approaches the question: has the entire interest been disposed of? And in my submission, the purpose I've identified at least supports the approach that one looks at the substance of how matters stand after the facts and circumstances we're inquiring into, as opposed to the effect of individual facts and circumstances as they occur, as they arise. So I think it's fair to say that throughout the litigation, various attempts have been made to identify what the purpose of the provision is, without necessarily a huge deal of success. But having been involved from the first tier tribunal, that's my best stab at it.
So, Mr. Simpson, the 36.2 may indeed have been designed to protect the interest of the final consumer, but it may not, in practice, given the debate that's taken place, be fully effective to do so.
Indeed, Lord, on its own, yes, it's not effective, but fully effective. But when taken in the context of the neighbouring provision in 36.3, I would submit that the two together are sufficiently effective.
Yes, thank you.
So on the basis of that purpose, as I mentioned at the start, returning to UBS at paragraph 68, the relevant fact in my submission is the outcome of this concatenation of facts and circumstances consisting of the sale and leaseback transaction as facts and circumstances that are relevant to the tax treatment of the first sale. Then, of course, those facts and circumstances have other VAT consequences because they are in themselves supplies, but we needn't worry about that because that's a separate matter to our inquiry. Just a few words about HMRC's written case on this matter. First, at page 81 of the bundle, at their HMRC's paragraph 48 of their written case. Towards the end of that paragraph, there are a couple of references to what the UK legislature has done, being that it gives zero rating with one hand, but takes back with another if there's a change in relevant circumstances. And that, my submission, is correct. What we're looking at is facts and circumstances rather than a transaction by transaction approach. Next, paragraph 49, the respondents say that the disposal of the entire interest in an acquired property can rightly be equiparated with a change in use, since the purchaser is no longer in ultimate control of the use to which the building is put. Now, while that might work in present context, where the supply by Fiscale to BCL was a sale, of course, zero rating is also conferred where the first grant is a lease. A lease of at least 20 years in Scotland and 21 years in England and Wales, because that counts as a major interest. So in my submission, what 36.2, to the extent that HMRC and the appellants agree that it is about a loss of control is not about a loss of ultimate control, the ultimate control of the owner of a care home, for example, because the initial zero rating doesn't require the recipient to have that ultimate control in the first place. And that is why, as HMRC point out towards the end of that paragraph, the appellant looks at a question of sufficiency of control. And in my submission, the control of a lessee must be sufficient to justify a zero rating being continued, because it's enough to justify a zero rating being granted in the first place. And finally, paragraph 50, where the respondents say it's no answer for BHL to point to the terms of, well, BCL's lease, since taxing statutes should apply to objective situations which are capable of being clearly ascertained. And that, of course, takes up one point of the Inner House's decision. Now, in the first place, zero rating itself depends on the terms of contracts between the parties. To get zero rating at all, you have to have a contract or a disposition being ownership, transfer of ownership, or a transfer of or grant of a long lease. So the transactions the parties entered into are actually objective situations capable of clearly ascertaining themselves. And that's nothing unusual in terms of taxing statutes. I'm not sure there's any tax that doesn't depend to some extent on the terms of legal documents entered into by parties. And of course, in the tax context, HMRC has all the powers it needs to obtain copies of those documents, and also, of course, to inquire into actings of the parties surrounding those documents. So my submission is a perfectly good answer to point to the lease, because the lease would have been sufficient in the first place. If it had been what had been acquired from Fascale to lead to zero rating of the supply, of that initial supply.
Mr. Simpson, am I to understand you saying you don't take issue with what the revenue say in the first 3 lines of paragraph 50, but you say that the objective situation which has to be ascertained is the composite contract, the composite transaction?
Yes, well, my submission is that inevitably the lease is an objective fact. That is, in my submission, one of the relevant circumstances for inquiry.
Yes, but are you objecting to anything said in the first 3 lines of paragraph 50?
Well, I don't object to the second and third lines, taxing statutes should apply, but the first line is wrong in my submission, that it is an answer. It is an answer to point to the terms of the particular lease.
But that gets back to the whole question, and that's the nub of this appeal. Yes. Do we look at a composite transaction of sale and leaseback, or do we disaggregate?
Indeed. Yeah. Indeed, my lord. And my point is simply that if what one is saying is one can only look at objective situations, well, that doesn't exclude the lease.
Well, clearly not.
No, indeed. At the end of that paragraph, HMRC say that if the appellant is right, then the problem arises because HMRC would have to monitor individual landlord and tenant transactions and disputes, perhaps over years, to identify when a lease was actually surrendered or terminated. But of course, my Lord and Lady, that is the case, where the initial zero-rated supply is the grant of a long lease, because it is the disposal of the tenant's entire interest in that long lease that would be within 36(2). Lords and Lady, that concludes my submissions about the interpretation of the lease. I've only got a few minutes left as regards Scots law, my Lord.
Yes, I just wanted to ask one question in relation to understanding the purpose of paragraph 36(2) insofar as one can. And I wondered whether it might be said that it interacts with the scheme of Group 5, Item 1, which one sees at page 1053, where zero rating is allowed in relation to the first grant by a person who's constructing a building of a major interest in or part of the building, and so on. And I just wondered whether it might be said that there's a certain sense in paragraph 36(2) in focusing on the onward entire disposal of P's interest as preserving the underlying scheme of the legislation reflected in Item 1 of Group 5, that it's in relation to the first grant that the zero rating applies.
Yes, yes, my Lord. So that's Item 1 is, of course, one of the provisions that 36(2) refers to. 36(2) also applies to zero rating transactions under 2, 3, and 4, which don't require the recipient to hold a major interest. Whatever interest the recipient held at the time of the zero rated supply is the one to which, well, that at least starts off as relevant to 36(2). Of course, my submission is that 36(2) inevitably can't be looking simply at the major interest required. But my submission is it's focused on ensuring this link between an input and a final consumer that's sufficiently close to justify a zero rating in the terms that the European Court of Justice referred to in the Commission Against United Kingdom case that our friend took the court to this morning. Given that perhaps larger context in which zero rating operates, my submission, the point is that it must be the, at least in some sense, that first recipient who forms the link between the input and the final consumer, and that policy, that scheme is met on the appellant's approach to the 36(2).
Yes, thank you very much.
But isn't the more natural construction of 36(2) that it's looking not for a continuation of the link between the operator and the end user, but the link between what the operator had before the relevant transaction and what he has afterwards? And that ties in, does it not, with the criteria used in Majesty?
Yes, my lady. So in terms of the natural reading of 36(2) itself, in my submission, it does more easily read by comparing, well, by looking at the situation before and after, as opposed to whatever individual steps in combination have led to the after outcome, so to speak.
And that's exactly what we're enjoined to do by paragraph 40 of Majdabel.
Yes.
Looking at user which is uninterrupted and permanent.
Yes.
The continuation whereof.
Yes, milady, that's it. That's exactly what our position is. I think that here there is no interruption in possession, exclusive possession or use, just as it wasn't in Majdabel. And looking at the bigger policy that allows zero rating to be conferred, our position fits with that, because that continued use by the first recipient carries on that link between the zero-rated input and the final consumer.
Thank you.
Mr. Simpson, I'm afraid you're now out of time.
Indeed,
but you said your enthusiasm for putting Scots law of property at the front of your submissions is limited, I think, in fairness. But you have those submissions in writing in your case, and you can be assured that we will have regard to them in our deliberations.
Yes, well, sorry, before the only point about Scots law, my submission, it is uncertain and not an adequate basis on which to interpret and apply this provision.
But I understand that's your case. Thank you very much.
The question from
Lord Briggs.
I just had one very short example, just by way of testing what your case implies. Assume that P first acquires a qualifying long lease, which is therefore zero rated, and then acquires the freehold reversion, which I assume would be exempt, but tell me if I'm wrong, and then sells the lease but keeps the reversion. Would subparagraph 2 be triggered? I think on your case, the answer is no.
That's right, Lord. In my case, the answer is no. I understand in HMRC's case, the answer would be yes.
Yes, that's my understanding too. Thank you very much.
And indeed, in HMRC's case, I think even if a long lease is extended in its term which has to happen, as I understand in English law, by surrender and re-grant, then that triggers 36.2, even though in substance, the beneficiary of zero rating is getting the premises for longer than he started with. So unless I can be of further assistance, I would simply invite the court to allow the appeal.
Thank you very much, Mr. Simpson. Mr. Beale.
Obliged.
My lords, my lady, I'm proposing to deal with our submissions in the following order. First, confirmation briefly of the nature of the transactions that have in fact taken place. That should be relatively straightforward. There seems to be a broad measure of common agreement on what they are in terms. Secondly, I would make some submissions on the principles governing VAT and zero rating in particular. Thirdly, I propose to address the proper construction of paragraphs 35 to 37 on their natural and ordinary meaning. Fourthly, I would then consider to what extent that natural or ordinary meaning needs to be moulded to give effect to the purpose behind the legislation. And finally, I would then propose to deal with the CJU's judgment in Majdabel. My learned junior is all primed and ready to deal with Scots law. It would be quite unfair of me to deprive him that particular hospital pass, and so I will invite him to make some short submissions on the impact of Scots law in this case. Now, the transactions are accurately described in the Statement of Facts and Issues, paragraphs 8 to 12. For your note, that's at pages 24 to 25 of the bundle. We end up here with essentially three separate transactions. First, there is, of course, the grant of a major interest in land. Here, that was the supply of ownership moving from Fiscali to Balhousie, and that was a major interest in a newly constructed building used for a relevant residential purpose. As has been indicated by my learned friends, item 1 of group 5 to schedule 8 treats that as being a zero rated transaction. that transaction is also a supply of goods and not a supply of services. Why? Because paragraph 4 of Schedule 4 to the VAT Act says so. So anything that is a major interest in land is treated as a supply of goods. Anything that's not a major interest in land would be a supply of services. A major interest, as the court is well aware, is defined in section 96 of the VAT Act. Here, relevantly, it would either be a 20 or 21-year lease and upwards, depending on the jurisdiction, or it would be ownership in Scotland, or the full absolute title in England and Wales. So it's common ground that that first sale from Fiscali to BCL is indeed a zero-rated transaction. And of course, what that means relevantly, I appreciate I'm at risk of stating the obvious, is no output tax was due on that transaction. But Fiscali was able to recover all of the input tax on the services and material it bought for the purposes of making that first grant of a building, commercial building, which is nonetheless used for a relevant residential purpose. So whereas most first grants of commercial buildings would be subject to tax, but would therefore also allow for input tax recovery, this was an exceptional case in which no output tax was due, but the trader still got the benefit of full input tax recovery in the hands of Fiscali. And we do say it's relevant and telling that there hasn't been much mention of the input tax position in any of my learned friends' positions, because of course one of the key features of VAT is that one needs to look at inputs and look at outputs, and it's definitely an input and output based tax. Now, in terms of the second sale, again here there is a measure of common ground, that it is not the first grant of a newly built building. It is a newly built building, but it's not the first grant, it's a second grant, and therefore it doesn't qualify for zero rating in its own right. It's therefore an exempt supply under item 1 of Group 1 to Schedule 9. And what that meant is that the transaction continued not to bear output tax, but any input tax incurred by BCL for the purposes of that specific transaction wouldn't be recoverable because it was an exempt supply. More generally, BCL was a partially exempt trader. It, as far as I know, didn't have a special method, and so it would have applied the standard method contained in the VAT regulations so that it recovered a proportion of its input tax generally, and that proportion would reflect the value of its taxable supplies versus exempt supplies as a proportion of its overall turnover. Now, the third transaction was the lease that you've seen. That lease moved from Target to BHL, so the direction of supply was different. It was a supply by Target to BHL, not a supply by BHL to Target, and that was also an exempt supply in this case, because there was no option to tax in relation to the property, and the default position is that interest in land, conveyance of interest in land is an exempt transaction.
I think, Mr. McBeal, you referred to BHL. It's BCL. It was a lease back to the person who had sold the property.
My lord's absolutely right. But I've committed the classic VAT error of treating the taxpayer as the person who physically receives the underlying transaction. It's because it's a group transaction.
And BHL is the representative member.
Exactly. So for VAT purposes, all of the supplies that I'm dealing with are to BHL and outwards again. But my lord's absolutely right that the actual underlying counterparty to the transaction was BCL. Forgive me if I misspeak. I'm using them in my head interchangeably. So what we don't have at the moment any visibility of is the involvement of Fiscali. We have referred in our written case to a first-tier tribunal decision, which your lordships and your ladyship will find in due course at page 1663. I don't think we need to turn it up for present purposes. Suffice to say that the involvement of Fiscali was mired in some obscurity as to exactly what its nature and purpose was. It seemed to have purported to have involvement in the two other transactions that aren't in issue in this appeal. The reason why they're not in issue is because the land wasn't conveyed, the building wasn't conveyed at the first instance from Fiscali to BCL. So you simply had transactions involving BCL and Target, And that brings into play a different VAT analysis from the separate involvement of Fiscali at the earlier stage. So here we have Fiscali, BCL, target. That particular tripartite nature of the transaction is missing from the other two transactions. What, however, the involvement of Fiscali did facilitate in my submission was 100% input tax recovery on the costs of construction. And I think somewhere in the papers there's an indication in the accounts, perhaps, or it's in fact in the capital allowance elections towards the end of the bundle, where Fiscali, BCL and Target are divvying up who is going to get the benefit of capital allowances under the 2001 Act between them. There's an attribution, I think, of the costs, and the costs are somewhere in the region of 650 or 700,000. If I've misspoken on that, my learned junior or certainly my learned friends for the appellants will correct me. But so a chunky sum of input tax was recovered by Fiscali on these construction costs in circumstances where, if BCL was the developer of the care home, it would have had to only recover, it would have been constricted in its recovery of input tax. It could only have recovered the input tax derived from the application of the standard method. And of course, that would have been a fraction of full input tax recovery in this case. So that, we say, is the relevant transactional background. I now move on, if I may, to my second portion of my submissions, which focuses on the overall scheme for VAT, and then looks in particular at the scheme for zero rating, which has a unique place within it. So this is addressed in our case at paragraphs 33 to 37, which your lordships and your ladyship will find in the bundle at page 73. Now, unlike other statutory schemes of taxation, be it income tax, corporation tax, or even stamp duty, land tax, VAT focuses on a number of elements. Firstly, the nature of the transaction in issue, who is supplying what to whom for what consideration, and also the direction of supply can have a significance. So it's a transactional tax on turnover. It's not a charge on profit, which has a built-in deduction of costs as against income. It's nonetheless a tax that permits a de facto deduction of costs at the previous stage, precisely through the input and output process that I've summarized already. All things being well, a standard rated chain of transactions will involve interstitial recovery of input tax on each of those chains, and output tax being accounted for then on the full amount, but with the requirement to account on the taxpayer being for the difference between the two. And what that produces, famously in the rather trite observation, I think, of one law lord, is that VAT is a tax on the value added. So within a chain of transactions, it's only the value added at each stage of them which generates the ultimate charge to tax that's payable by the taxpayer, having taken into account the costs at the input stage. Now, that comprehension of the VAT regime operating in that way can be derived from a pithy summary in a judgment of the Court of Justice in Elida Gibbs. The court will find that at page 1768 of the bundle, tab 62, and the particular parts can be picked up, I think, at page 1773 with the relevant facts behind the case. In short, Elida Gibbs, so picking it up at 1773, Elida Gibbs basically was involved in the retail supply of, or wholesale and retail supply of cosmetics. It issued money off coupons, which the consumer could then bring to the relevant branch of Boots or wherever it may be when cashing in the coupon and getting the cosmetics back. And that essentially operated as a post-supply rebate of the sum that the consumer was paying. The coupon having been handed in, the retailer would then submit the coupons to the wholesaler, and there would be an exchange of funds in order to represent the discount that had been offered to the consumer. The issue in that case turned on, was it possible, as the revenue contended in that case, to take into account the coupon as a form of non-monetary consideration so that you ended up with a charge to tax that reflected the full value at the point of sale, i.e. coupon included, Or should the coupon be construed as a money rebate after the point of sale so that the taxable amount for the transaction was reduced? The point I derive from it, the proposition I derive from it, can be seen at page 1776. And please could I invite the court to read paragraphs 19 through to 24, which set out the overall structure of the VAT regime that I sought to encapsulate a moment ago. What that generally means is that for any given transaction in a VAT dispute, one is focusing, depending on whether or not it's an input tax question or an output transaction, on a given transaction. It's always a transaction involving usually two people, sometimes three or more people, but ultimately you'll be focusing on one link in the chain. Exceptionally from that, it is of course possible to broaden the inquiry when looking at VAT issues. A classic example would be the case of fraud, and the court will be well aware of the carousel fraud cases that have been rumbling through the courts since 2003, 2004. I've included in the bundle of authorities the CJU's judgment in Optigen, which was a classic early case of how to deal with the problem of carousel fraud, in that case I think in computer chips and mobile phones. And the Court of Justice there recognised that one should follow a case-by-case analysis, even in cases where fraud is alleged somewhere else in the chain, unless it can be shown that the taxpayer knew or should have known about the fact that there was fraud elsewhere in the chain. And whilst you don't have the case before you, it's then since developed in the Cattell case to be a test whereby if HMRC is able to establish that the taxpayer knew or should have known that the relevant transactions were vitiated at some point in the chain of transactions by fraud, they are entitled to deny input tax recovery to that particular taxpayer for the transactions in question. So that's an example of the Court of Justice saying, exceptionally, we look beyond the specific transaction in question and we're prepared to treat the question of, in that case, input tax recovery by reference to other transactions. Another example concerns abuse. As the Court of Session identified in its decision, and as this court will be well aware, the case of Halifax is an example of the European Court of Justice recognising that the concept of abuse of rights under EU law can be applied in the VAT sphere. And the court there famously developed the two-limb Halifax test. Is there an intention to obtain a tax advantage as a result of the transaction in question? And is the means by which that tax advantage is obtained beyond the normal commercial boundaries? So is it an artificial structuring of a transaction which produces a consciously favourable tax result? The two limbs are set out in paragraphs 74 and 75 of the Halifax judgment. Now, absent those sorts of situations, for VAT purposes, one generally simply looks at the transaction in question. Who is supplying what to whom, for what consideration? And so there isn't, with the greatest of respect, much room for the Barclays mercantile type approach, which I notice in any event hasn't featured strongly in the oral submissions, if at all, from Malone and Friends this morning. So conceptually, we're in a position whereby if there's a different tax regime with a different way of establishing the charge to tax, a different way of establishing the taxable amount, and different considerations as to the scope at which you look beyond the individual transaction, that statutory framework is not going to be a very good bedfellow for comparison purposes when construing VAT legislation, which necessarily finds its home naturally in a transaction by transaction based approach, as the Court of Session, we say, rightly found. Now, that doesn't, of course, mean that when construing a particular provision, every aspect of it is necessarily determined by a transaction by transaction approach, but it is necessarily part and parcel of the context in which in this case, a charge based on a self-supply arises, that VAT is indeed focused usually on the preceding transaction and the subsequent transactions to work out what the taxable amount should be, for example. So plugging that particular submission into the issue here, when in due course I turn to look at paragraph 35 and 36, Schedule 10, we do say it's important to realise that the legislature has deliberately chosen to refer back to a particular transaction. And that particular transaction is the zero-rated transaction in question. And when Parliament, through the negative resolution procedure, has adopted that particular form of words, Parliament has done that in the context of a predominantly transaction-based tax. And we do say that is important context for the process of statutory construction, which ultimately this appeal is all about. Now, conceptually, of course, it's difficult to see a situation in which a different way of calculating tax would be terribly relevant. If, for example, one has to look at the global state of affairs, then why are we leaving out of account the fact that Fascally obtained 100% VAT recovery of the input tax? Because if one is broadening the scope of the inquiry beyond the particular transaction identified in paragraph 35, then you have a disjunctive effect of 100% input tax recovery on a zero-rated transaction, a subsequent transaction which is not zero-rated, but which in effect the benefit of the input tax recovery is obtained by that particular taxpayer. And then the issue is, does a subsequent transaction mean that the original conditions for the grant of zero rating are still maintained? And in our submission, what Parliament has chosen to do in the phraseology it's used is indeed to identify the circumstances under which zero rating will be and won't be permitted. And that was indeed the entire purpose behind these changes. Now, the second key feature of the VAT regime that I light upon is one I've already referred to now twice, which is the process of classification requires one to identify a supply of goods or services. So who supplies what to whom is the touchstone for defining the chargeable event. And from that determination, one derives typically the classification of the supply for VAT purposes. Is it standard rated? Is it exempt, or is it zero rated? And also the identity of the person who will be liable to account for VAT. So direction of supply is important as well. It's not just that different contractual circumstances can lead to different classification as either standard rated or exempt. It's also that the person who is liable to account could change. And so the direction of supply is important. Now, in relation to supplies of goods and services subject to VAT, it is the transaction itself and not the payment or given by way of consideration that is the important feature. And that proposition is vouchsafed by the Court of Justice's judgment in the Cantor-Fitzgerald case, which the court will find at page 1848. Now, this case concerned essentially a payment by a tenant who wished to depart from its capacity as tenant to an incoming tenant who would be taking the benefit of the lease. And there was essentially a payment by the departing tenant to Cantor-Fitzgerald to take over its obligations, subsume its obligations under the lease. And at paragraph 13, page 1855, Cantor argued that the amount of money that it had received simply reflected the price it otherwise would have been paying for the assignment of the lease. But there was in fact a separate payment that had been made by the departing tenant, simply to by way of persuading Cantor Fitzgerald to assume the separate obligation under the lease. And what Cantor Fitzgerald was keen to do was to say, effectively, this is all part and parcel of a lease arrangement. I simply could have paid less for the lease rather than giving the money separately to the departing tenant. And it could have been structured in a way in which the whole thing was done on a lease basis. The court dealt with that, starting at paragraph 17, noting there that it's supplies of services which count and not the payments which people make. That's the proposition for which I cited it a moment ago. But the court then also went on to explore the reasons why the supply by Cantor Fitzgerald to the departing tenant of assuming the obligation under the lease was not in itself a supply of a right to occupy property. And that is perhaps of more interest. Would the court be kind enough, please, to read paragraphs 20 through to 25, where the nub of the point is taken? Paragraph 25, we have the common statement that applicable as much to zero ratings as to exemption, that because it's a derogation from the standard rating of VAT, it should be applied strictly. I've accepted in our case, and therefore I hope it's common ground, but that doesn't mean you can deprive an exemption of its true effect, but it does mean that what one necessarily has to constrain the full ambit of exemptions, because otherwise they would run away with the tax. Turning then, if I may, to paragraphs 29 to 32, we see that the taxpayer's concern that it could have achieved the same result by a different route didn't draw any sympathy from the Court of Justice. So we see the court recognising at paragraph 29 that the factual and legal context of a true surrender case, where somebody surrenders their lease in return for a payment and the treatment of that as an exempt supply of property, in that case in Lubbock Fine, was different because the facts and legal framework were different. Now, it's true, then recognised in paragraph 31, that Waco could have remained as a tenant and sublet the property, which would have achieved a different result. And in both cases, the economic impact would have been comparable. But again, that's not what they'd done. And therefore, see paragraph 32, what you can't do is construe relevant provisions of EU law by reference to the economic impact alone. You necessarily have to look at the legal and factual framework for them. And if the consequence of that is, well, you've ended up with a VAT liability you could have avoided another way, then that's tough, to put it colloquially. Paragraph 33, we see confirmation of the approach in BLP, that one necessarily has to process VAT classification by the objective criteria rather than any subjective intention or any commercial motivation that might otherwise be the justification lying behind a particular transaction. So the fact, for example, that you've got a choice of different ways of achieving something as an economic goal doesn't mean that you roll out the same VAT treatment for those transactions. And let me plug that in again to a practical example on the facts of the current case. If, this taxpayer had granted a long lease of the property and obtained a lease back of a lesser interest as part of a financially motivated transaction to get funding for the overall transaction, that wouldn't have triggered the self-supply charge. It's because they chose to dispose of the entire interest in the property, and that was the structure they used, that this charge arose. And indeed, I can make that good by pointing out that that's exactly what the commissioners were advising people back in 2011. So a good 2 years before this was put into place. If one looks, please, at page 1714 in the bundle. there is an extract from Devoyle, the loose leaf surface. Essentially, Devoyle summarises the relevant statutory provisions at paragraphs 35 to 37. It then sets out a series of examples. Those examples are derived principally from an HMRC information sheet that one sees cited at page 1717, footnote 26, information sheet 4 of 11. Devoyle summarises it perfectly well without needing to turn up the original information sheet. At 1714, we see scenarios involving buildings used for a relevant residential purpose. Halfway down the page, a new building, this is given as an example, a new building was purchased at zero rate for 5 million from a developer by a company that intended to use the building as a care home. After 5 years, in order to raise capital, the company sells a long leasehold interest for a premium to a finance company. The finance company leases the building with an open market value rent back to the company, who continues to use the building as a care home. Will the operating company have to account for a self-supply charge? No, because the operating company continues to use the building for a qualifying purpose. There's been no change in use. But more importantly, there's also been no disposal of the entire interest in the property. And so, whilst my learned friend has founded heavily upon the Majdebel case, Majdebel was a case of lease and leaseback. When one, and I'll come to this right in my submissions, but I may as well sort of grasp the bull by the horns now, because it seemed to me it was a point that was troubling the court earlier. Majdebel was a lease and leaseback case. The court said in terms, in a paragraph you weren't taken to, paragraphs 41 and onwards, if in fact you treat it as an entire disposal of the ownership of the property, i.e. it's a supply of goods, then you have a different outcome. And you do have a need in that case to make an adjustment for the capital goods scheme. Now, this case is not a capital goods scheme. Why is it not a capital goods scheme? Because one needs to have input tax borne by the relevant taxpayer in order for an adjustment to be required to be made to that input tax. And here, BCL never incurred any input tax because it was a zero-rated supply. Majdebel, in contrast, was the developer and incurred the construction costs and alteration costs and was seeking to recover those costs for its taxable supplies. The issue, therefore, was, is there an adjustment required under either general principles or the capital goods scheme whereby there is a clawing back of an aspect of the input tax it's using for that building? Answer, no, because it hadn't made a supply of that building as a supply of goods. So there was no relevant supply of the goods that was subject to the capital goods scheme at any stage. The court said, if, however, they had disposed of tangible property in a manner which enabled the recipient to dispose of the property as if it were owner, that would be a supply of goods and you would need to make an adjustment. And in that case, if, for example, the National Court found as a fact that there was a disposal of the right of ownership, then it was an exempt supply. Because it was an exempt supply, that would have required an adjustment for the recovery that had gone on at an earlier stage, and the taxpayer would have had to give back part of the input tax it had already recovered to reflect the exempt supply of goods it had made. So in short, Majdebel lease and leaseback doesn't involves the capital goods scheme. Neither of those is relevant here, but in any event, the Majdebel analysis, lease and leaseback, giving rise to a financial transaction, answer not a self-supply. So the concern that the court may have had, that what's wrong with a lease and leaseback transaction that's a perfectly sensible way of obtaining finance, nothing, and it wouldn't trigger a self-supply.
But
So,
could you just take us to paragraph 41 of Majdebel? This is quite an important point.
yes,
The conclusion of the court is that there was a single transaction.
I'm sorry, I may have cited the wrong paragraph because I'm doing it out of turn and without my notes.
Well, in that case, could you just check?
Yes. My lady's quite right. 41 is the bit that says it's not a supply of goods. Why is it not a supply of goods? Because Majdebel did not empower the financial institutions to dispose of the buildings at issue as if they were the owners. So that's the section that says it's not a supply of goods. The follow-on, which is the consequence if it is a supply of goods, is dealt with at 45 to 48. So I'm sorry, I misspoke. You were taken to 41, you weren't taken to 45 to 48. If the court would be kind enough to read that, it will probably save, I hope, if you did have any nagging doubts about this. I was hoping to take it in sequence, but it's easier to address those nagging doubts now.
But that's only an alternative. It only arises if it is not a single transaction.
Well, my lady, it arises if the way of characterizing the supplies that have taken place is as a supply of goods. Now, the court's reasoning essentially was twofold. Firstly, there hasn't been a disposal of tangible property, so there's therefore no supply of goods. We're therefore in the realm of supply of services. And because we're in the realm of supply of services, the court was willing to look at what the functional equivalent of the lease and leaseback was. Lease and leaseback would be exempt supplies of services here because they're not supplies of goods. And given that the motivation was a financial one, the court is sort of tacitly accepting that this is a supply of services that doesn't alter the use of the capital good. Why? Because the capital good remains throughout in the, not just the possession, but the ownership of the taxpayer. There's therefore no need to apply a regime which requires an adjustment to the use of a good because there is a supply of services.
But once you had answered question 1 in that way, then you never get to question 2.
Well, it's absolutely right, my lady, that if the National Court finds that there isn't in fact a supply of goods and therefore there's no need to adjust the input tax claimed on those goods, and therefore what one's dealing with is a supply of services, then we're in a position where you don't need to worry about the adjustment because no adjustment is due. Mm-hmm. So the court is necessarily saying, if you, the National Court, nonetheless find that as a result of whatever peculiarity, shall we say, of domestic property law and questions concerning ownership, if the result of that emphyteutic transfer is that there has in fact been a conferral of a right to dispose of the property as if the recipient were the owner, then there is a supply of goods and you do need to make the adjustment. So the Luxembourg court in the traditional way is saying, we think it's probably this, but of course it's for you to make the ultimate decision. If you think the answer is different, this is what you should do. So it's either it's simply not a supply of goods, therefore no adjustment is necessary, or if it is a supply of goods, an adjustment is necessary, and nothing in the general principles of EU law stops that happening, because it's simply part and parcel of the way you've chosen to structure a transaction.
Yes, are you going to say more about the first question then at a later point?
Yes.
I see. Right.
I mean, it comes at the end once I've explained how it all works, because one needs to see what how it works mechanistically through the process of statutory construction, and also what the purpose behind that is. And I apprehend Lord Briggs, amongst others, will have questions for me as to what's the statutory purpose served by paragraph 36(2), and I hope to cover those as well. Once you've worked out domestically how it works, the question then is, does Maidebel compel a different answer? In my submission, no. And I've tried to cut to the chase by saying a lease and leaseback here would not trigger a self-supply charge. So what happened in Maidebel, if you plug that into paragraph 35 and 36, no change. Now, I think I dealt with...
Just for clarity, Mr. Beale, you would say that even if the lease out was of 1,000 years?
Yes,
at a peppercorn ground rent.
The difficulty comes because Mr. Anderson will leap in and tell me I need to be careful, because in Scots law, as I understand,
all right.
exceeding a certain number of years is treated as ownership.
I think that may be true in England as well, but I'm just trying to give a fairly extreme example to test your case without looking at the realities of any system of law. As
a matter of English law, which I'm qualified at the moment to talk about, the grant of a 990-year lease with the reversionary interest remaining with the building owner, would not be the disposal of the entire interest, because the reversionary interest would be retained.
Yeah. And even if the reservation of any kind of ground rent was purely nominal.
Yes. And conversely, if one's dealing with a major interest at the bare minimum of, say, 21 years, if there is a disposal of the full interest of 21 years to somebody else with a sublease back of, say, 19 years, answer, that is a disposal of the entire interest that was the subject matter of the zero-rated transaction. So a self-supply charge would arise. It wouldn't arise if somebody who had been given a 21-year major interest in land made an onward supply of a lease of 19 years. And then there was a sublease back of that 19-year lease.
But that all depends what is a single or multiple transaction.
My lady, up to a point, because of course the acceptance that this is a composite transaction requires one to look through the fact that there are supplies moving in two different directions by two different taxpayers. Mm-hmm. And I'm afraid I don't accept that the consequence of the NEC decision and part service is that one can simply, absent a sham, or indeed particular circumstances, necessarily look through a transaction that involves different people giving different things to each other.
So that's something you're going to come on to.
It is, indeed.
But this is crucial.
Yes, I accept that. For my sins, I was involved with the UK government in both Bookit and NEC, which were heard at the same time. In a nutshell, Bookit and NEC proceeded on the assumption that there were two separate contractual arrangements. One going from whoever the service provider was. In Bookit, it was Odeon Cinema, and in NEC, it was the events holder, so the people who were organising concerts. And then there was a separate contract between the people who were in charge of the payment service aspect of it, Bookit in one and NEC in the other. And they had a separate contract with the end consumer, which was the unusual feature. And for better or worse, the domestic tribunals had not liked the suggestion that all of that was simply an agency arrangement. And they stuck to their guns and said, no, these are two separate contracts. And what one sees in each of the CJU judgments in Bookit and NEC is the court expressing or raising a metaphorical judicial eyebrow as to whether the domestic courts missed a trick. Why are you letting this go ahead unanalyzed? The answer is it was the tires were certainly kicked on that particular argument, and we lost them.
I think I was in Bookit.
Well, Bookit took two forms. There was an earlier one with Sir John Chadwick, which reached a conclusion. Yeah. There was then a subsequent Bookit where there was a suggestion made, I'm afraid by me on behalf of HMRC, that times had moved on and the scope of the exemption had been redefined, and we secured a reference. And the Court of Justice agreed with HMRC that the scope of the exemption was narrower than had been suggested by the Court of Appeal in Bookit 1. But true it is that Bookit 1 and the analysis of the agency arrangement was something that HMRC had not been given permission to challenge and couldn't challenge. So we were, if I can put it this way, again colloquially, I regret, we were stuck with the facts as found. We then had a legal argument, and the Court of Justice, rather to my irritation, said, well, have you not thought of this? To which the answer is, of course, well, we had thought of that, but we lost it. So that, as a matter of realpolitik, is where we ended up. But when one looks at what the Court of Justice is doing in those cases, it is saying what's wrong with simply glossing over the role of the intermediary in the payment services, cutting to the chase and recognising that what is going on here is, from the consumer's perspective, they're buying the right to attend a concert, or they're buying the right to attend a cinema. That's the standard rated supply. The fact that they are hiving off a separate charge for payment is irrelevant, because that's all part and parcel of what the consumer has to pay. Therefore, why don't you treat that as a single composite transaction moving from the event holder to the consumer directly, leaving essentially the intermediary out of the equation? So it's encouraging a quasi-agency analysis, and the court then reluctantly says, well, of course, that isn't what the referring courts found, therefore we're going to deal with the scope of the exemption for payment services. But as matters stand, in my respectful submission, what it doesn't give you the right to do, absent an allegation of abuse or fraud, is look through the contractual arrangements that have been put in place by contractual counterparties have recourse to an overriding economic approach, Cantor Fitzgerald surely end up in the same position as a matter of economic reality, and redefine the transactions. And so support for that proposition is in my next case, which is Secret Hotels 2. I should take this a fair lick, because I'm sure that this...
Can you just give us the references to your skeleton argument too?
Yes. This section generally is dealt with in a fairly compressed section, which is paragraphs 33 to 37 of the case. So I have, in fact, in the case, we have, sorry, in the case, set out in some detail Secret Hotels 2 and the propositions derived from them. As the court will be aware, this was a case involving hotel provision over a website. Could you please turn to page 1614, which is the start of the case. In a nutshell, there was a website run by Secret Hotels 2. What it did in terms was to advertise hotel space for consumers. Consumers would then book the hotel space through Secret Hotels 2. Secret Hotels 2 would then contact the owner and ensure that the hotel accommodation was secured. But the strict contractual obligation was between the hotel provider and the consumer. And so, as the court found, Secret Hotels 2 was actually acting as an intermediary throughout. The propositions I derive from it essentially concern the starting point for VAT analysis more generally, which is to look at the contractual terms and the way that the parties have chosen to structure their relationship with one another. And that can be found in the judgment of Lord Neuberger, starting at paragraph 23, which is at page 1623 of the bundle. So that's page 1623. Could the court please read paragraphs 23 and 24? Paragraph 29, on the bottom of page 1624, the learned judge then refers to the CJU judgment in Newey, and he cites paragraphs 42 to 45 of Newey. Please could you read that section? It will save me having to turn up Newey separately. And also then please paragraph 30 and its focus on the contractual relationship between the parties. And moving on to 32, Lord Neuberger identifies that when interpreting the agreement, the court must have regard to the words used, provisions of the agreement as a whole, surrounding circumstances so far as known, and the commercial common sense of the standard contractual interpretation principles. When deciding on their categorization, governed by a written agreement, labels aren't conclusive and may often be of little weight. And there's then a reference to the judgment of Mr. Justice Lewison in A1 Lofts and the Street and Mountford example of lease versus license. He then says in paragraph 33, in English law, it's not permissible to take into account subsequent behavioural statements of parties as an aid. Subsequent behavioural statements of the parties can, however, be relevant for a number of reasons. First, if there's a sham alleged, and secondly, they may be invoked in support of a claim for rectification. So ordinarily, one looks at the transaction in question. There isn't then this attempt to try and mould the overall contractual relationship by reference to economic realities, if in fact the contract does what it says it does. And if the contractual arrangements are chosen by the parties, then of course a great deal of latitude needs to be given to them as to how they structure their arrangements. Now here, of course, BCL chose to structure its sale and leaseback as being a disposition of the entire interest in its property and a leaseback of a lesser interest, namely a leasehold interest. But we say it's, I'm afraid, wrong to try and redefine that contractual position, either by reference to hypothetical facts or by reference to the economic outcome. Because if one starts saying, well, we could have achieved the same result in a different way and that wouldn't have borne the self-supply, the answer to that is, well, yes, that's obviously the case. You could have done things differently, but you didn't, and it was your decision. Now, the third feature of that that I propose to alight upon is that based on its objective characteristics. And my proposition is essentially that one looks at the objective characteristics of the transaction and not subjective intention of the parties. That is supported by the approach of the CJEU in the BLP case, the BLP group case, which the court will find at page 1755. It was a judgment of the Court of Justice. BLP was a management or holding company. One sees that at page 1757, paragraph 3. It acquired some trading companies, which were its subsidiaries, and then to pay off some debts, it wanted to sell the shares in those subsidiaries. The share sale was an exempt transaction. The question was, could it recover professional fees it incurred from bankers and accountants and so on in dealing with the share disposal? Answer, no, because the share transaction was an exempt supply and input tax incurred in relation to an exempt supply is irrecoverable. BLP tried to get around that in a number of ways. Firstly, they said, because it more generally carried out taxable transactions, see paragraph 12, page 1761, it should have its right to recovery recognised. The answer to that was that there was a direct and immediate link with an exempt supply of shares and therefore input tax couldn't be recovered. But in order to protest the merits of that point, BLP pointed out at paragraph 15, page 762, that it could have obtained a bank loan, achieved the same result, and it would have been able to deduct the accountancy fees and so on incurred in relation to securing the bank loan in full, and wasn't that unfair? The answer from the court, I'm afraid, was a more stylistic version of tough, and that can be seen at paragraphs 24 through to 26. Please could the court read 24 to 26, that's at page 1764. The short point, therefore, that follows is that whilst the motivation for the transactions entered into may have been to secure financing, that financing could have been obtained in different ways. It could have been obtained, for example, by a loan secured by a standard security. It could have been obtained by a lease and leaseback, but that's nothing to the point because one needs to analyse the transactions on their objective characteristics, not by reference to any fiscal or commercial motivation that may have been underlying it. My fourth submission, based on the overall principles.
Mr. Beale, I mean, clearly this is authority that you can't look to the fact that there may be another way of doing it to achieve the same financing purpose. But does that mean that the court should turn a blind eye to the fact that this was a transaction between a care home and a financier, and that the sale and the leaseback were part of a general financing package? i.e. The fact that it was a financing package wasn't an objective characteristic of the elements of the transaction.
Right.
Well, the answer directly to my Lord's question is no. Obviously, that is a relevant part of the factual context, and indeed it's been cited by both the upper tribunal and the inner house for that purpose.
Yes.
There's a different question as to whether or not that motivation or that context necessarily drives the fiscal treatment for VAT purposes, and the answer there is no, it can't. The fact that it was part of a, in inverted commas, financing transaction makes no odds if it's not a supply of credit or a financial services, supply of financial services, if what one is dealing with is the second grant of a major interest in land representing the entire ownership of the property, then the objective characteristics of the transaction in question are that. And the fact that it's part and parcel of a overall financial package designed to achieve a result can't change that objective characteristic, because that would be to reshape the transaction in question by reference to the ultimate motivation rather than by reference to what is the bare bones of the transaction that we're dealing with. And that's true for general VAT classification. It also, we will submit in due course, is necessarily part and parcel of the paragraph 33 to 37 analysis, with its implicit recognition that you have to focus on what was the specific transaction that was zero rated, and are the conditions for zero rating still met at a given point down the line. And if they're not, there's a self-supply charge to VAT, which effectively restricts the original, the grant of the zero rating that was always inherent in the initial benefit conferred.
Well, the disposition by BCL to target was the supply of a major interest in land.
It was.
Yes, and if you ignore the existence for this purpose of the prior zero-rated transfer from Tuscany to Balhousie, then it was an exempt supply.
Yes.
Yes, and what this provision is concerned with, it isn't taxing the transaction, that transaction, BCL to target as such. What it is considering is whether or not there is to be deemed to be a self-supply to BCL.
Yes. If you imagine,
so in that context, why is it important? Why is it important for the consistency of the supply chain that there be that there be a restriction on the matters that you can consider as relevant when ascertaining whether paragraph 36(2) is met?
Because the statutory wording in paragraph 35, that I'll come on to, I hope, shortly, defines the relevant transaction, and what 35 and 36 and 37 are doing is restricting the scope of the zero rating that is granted by a separate provision in Group 8. And so whilst item 1 of Group 8, item 1 of Group 5 to Schedule 8, sorry, of the VAT Act, confers zero rating on the first grant, that in the light of Part 2 of Schedule 10 is only for so long as the relevant conditions of that zero rating grant are met. And
Yes.
as said through statutory changes in 2011, that if in fact within a period of 10 years following that first zero rating grant, you dispose of the entire interest that was the subject matter of that first zero rating transaction, then you bear a self-supply charge to reflect the fact that we are not going to give you zero rating. That's simply part and parcel of what Parliament has said is the ambit of the zero rating that is conferred at the first stage, because Schedule 10 necessarily has to be read alongside Schedule 8. The relevant provisions when introduced, say Schedule 10 deals with buildings and land, and Schedule 8 has to be read in the light of it.
Will you at some point take us to the transactional documents? Because the submission was made to us, the target never takes free of Balhousie's interest.
So Junior, Mr. Anderson will take you through the specific contractual documentation because it's a matter that arises under Scots law, with which I'm afraid I'm not terribly familiar and even less qualified. So I'm not going to make that submission if I may.
It is not a matter of general property law, it's a matter of contractual documentation, and that's the basis on which the case was put.
The contractual documentation, the missives show that there was a sale and leaseback, and it was what I would call part of a preordained structure whereby there would be a sale and then a leaseback.
And they were taken through the documentation.
My lady, of course. But
Very
as sort of what do the documents actually show? They show a disposition of an entire interest by Fiscali to Balhousie, and then a separate disposition of the entire interest by BCL to Target.
But with a provision in the missives to the effect that the Target's right of possession was subject to the leasehold interest, which was conferred simultaneously.
Yes, and if I'm being pushed to say, is it right that Target obtained an interest in property that was subject to the lease? The answer is yes. It was. That's exactly what it obtained. But the question is, as a matter of contractual, of statutory construction of the relevant provision, has BCL disposed of its entire interest in the property? Answer, yes. The interest it now holds is a different interest provided by a different property owner, and it is a leasehold interest. And so it's not in the position it was previously, whereby it was the owner, it was free to do as it willed. It's no longer the master or mistress of its own destiny. It's it's beholden to a landlord, and it has, as my learned junior will show you, some pretty stringent commercial terms to make sure that it complies with any number of things, not just maintaining the property in good order, but also financial obligations to report X, Y, and Z. Obviously, the user obligation to carry on using it as a care home. It's a suite of pretty stringent landlord and tenant obligations imposed mutually between the two. And the landlord, for example, has an insuring obligation as well. So the idea that BCL retains ownership of the property is simply wrong. And if the statute says the benefit of zero rating attaches to the first grant of ownership, and that is the transaction one's looking at, and if the consequence of the transactions down the line is that BCL no longer has ownership, then it has disposed of the entire interest that was the subject matter of the zero rating transaction.
But it is odd that one speaks of ownership earlier on in the line, and by the time you get to paragraph 36.2, you use the non-technical words entire interest.
But it's an entire interest by cross-reference back to the definition of the transaction under paragraph 35, which necessarily and implicitly is a grant of a major interest in land. And my learned friend said, oh, well, it could have been any of the other suppliers under items 2, 3, and 4, I think. Subparagraphs 2, 3, and 4 of item 1. Each of those individual supplies, they're sort of non-architect consultancy services, building materials that are incorporated in the building itself. You're not going to have an onward supply of any of those supplies. Once they're done, they're done. They're incorporated in the building. The non-architects consultancy services have been used up. You've got the finished building, that's it. It's the building that moves on. Now, the value of the building may necessarily subsume the value of the services and the material that got into it. But the idea that one would have an onward supply of the material that's been physically incorporated in the building is a nonsense. And so in practical terms, when one's looking at the terms of paragraph 35, it's dealing with a second grant of a newly completed building for present purposes. And that second grant is not subject to zero rating. And so one is immediately establishing a stopping or a cessation of the original conditions that govern zero rating, which were conferred for a period of time, the adjustment period, which mirrored the fact that property is an asset that's held for a significant period of time. Benefits of it will be derived over a significant period of time on standard commercial terms that's subject to depreciation on a write-down basis. And the 10-year sliding scale of the self-supply charge reflects that.
Yes. Well, I'm very content that we leave the subtleties of the law admit it to Mr. Anderson. But are you going at some stage to expand on what you've just now said?
Yes.
As the policy behind the entire interest provision?
My Lord, yes, of course. You'll appreciate that I've taken something slightly out of turn, but I've been keen to try.
I'm happy to take it in the order you want, but I do want to cover and hear your reasoning as to the thinking behind the entire interest criterion.
Yes. So the fourth element of the VAT that I wish to emphasise, in fact, I've already made this point, so it's simply a reiteration of a slight nuance of the point I've already made. Whilst economic reality is a feature of VAT analysis, what you don't do is transmogrify the actual underlying supply to reflect economic reality if that runs counter to, for example, the contractual treatment or the proper analysis of who supplies what to whom. So that's in the Cantor-Fitzgerald point, that was paragraph 33. It's a discrete point, which nonetheless bears emphasis. My lady will recall perhaps the ING intermediate case involving so-called free banking supplies, where it sought to be repackaged as a receipt of credit by the bank. The answer was that whilst economically it may have involved an element of a receipt of credit, in commercial terms what was being supplied was a banking service by the bank. Now, the fifth point is really a corollary of the fourth, and it's a short point, which is that a small change in the relevant commercial structure, commercial transactions, can make a big change to the VAT treatment. And that is the point derived from Lord Reed's judgment in WHA Limited. It's dealt with in our case at paragraph 14. For your note, the specific paragraph is at page 1605, but I don't propose to turn it up. It's a truism of VAT that if you change things around, you may end up with a very different result. Now, the fact here that we're dealing with buildings and land also brings its own delightful complications to bear, because unlike many supplies perhaps, land and buildings are one of those supplies that can either be standard rated, for example, commercial property. They can be zero rated, for example, the first grant of a dwelling or a first grant of a commercial building used for a relevant residential purpose, as here, or they can be an exempt supply, which is ultimately the default position. And so where you have, as here, a series of connected transactions, it's, with greatest respect, difficult to default to a single supply analysis without being at risk of folding into the mix different transactions from different taxpayers that bear different VAT classification. So if, for example, we were in a different sphere, one might end up in a situation where, for the sake of argument, the original supply was standard rated, was exempt. There was then an option to tax, and that might change things at an interstitial stage in a series of transactions. And that has all sorts of complications and, dare I say, opportunities for tax advisors that one's seen historically in cases such as Halifax and others, where opting in and out of the regime gives rise to a potential for tax advantage. And of course, having had our knuckles rapped by the EU Commission in the case that my learned friends took you to on the scope of zero rating for commercial property, one can see why Parliament was keen to ensure that the treatment in 2011 of zero rating was kept within defined boundaries. Now, one sees, for example, the scope for different tax treatments to arrive at different stages in a series of transactions in the Robert Gordon's College case, which was a judgment ultimately of the House of Lords, Lord Hoffman giving the speech with whom everyone else agreed. My Lords, my Lady will find that at page 1323 of the bundle. The case concerned some building works that were being conducted to a private school's sports ground. The school in question put in place arrangements whereby it had building works conducted, construction, I think, of some changing rooms and so on, and some work done to the sports ground itself. It put in place a lease to a standard rated through a standard rated transaction because they opt to tax the transaction, at least to a connected subsidiary. The subsidiary then had a standard rated license back to the school, and the consequence was that the school in principle was able to recover input tax, even though it was primarily making exempt supplies of educational services. Now the question was whether a particular section of the self-supply requirements of the statute at the time required a charge to tax, a self-supply charge to tax to arise. And at page 1329, we see Lord Hoffman identifying the purpose behind the self-supply charge. And it was essentially that, given that the UK had had its knuckles wrapped with the EC Commission versus UK decision on commercial property, there was potential disparity of treatment between a developer who built a development on its own land and then made a taxable supply of property, and somebody who simply built the underlying land but then had the building services brought in separately. And there was concern that this would give rise to a mismatch in treatment. And the consequence was, therefore, that if the developer ended up using the development themselves for their own purposes, there would be this self-supply charge. And one sees that at paragraphs B to D of the speech of Lord Hoffman. And as a matter of purely domestic analysis, it was recognised that what happened in this case amounted to the use by the taxpayer of the relevant interest that had been granted. However, applying an analysis derived from the 6th VAT directive, Lord Hoffman considered it wasn't appropriate to look at the global picture in circumstances where the school had received the initial construction services, it then ultimately derived the benefit of the development. It was appropriate to focus instead on the chain of transactions in question and to understand that the school received the benefit of the developed land in the form of the grant of a license to occupy, which was a separate transaction from the initial grant of a lease and a separate transaction from the initial construction works that the school had carried out when it was the owner unencumbered of the property in question. And one sees at page 1331, the Court of Session had treated it very much as a global picture. It was sufficient that the school ultimately derived the benefit of the works, and it had itself incurred the input tax on those works in the first place. The House of Lords took a different view, which was that for the purposes of the EU value-added legislation, it wasn't possible to take a global view of a series of transactions in the chain of supply. Instead, it was appropriate to see whether or not the college used the land as a service supplied by a third party, it being irrelevant that it had developed the land at an earlier stage. So a stage-by-stage transaction approach was necessary. And one sees then at page 1330, paragraph E to F, that each transaction in the chain must be examined separately to ascertain objectively what output tax is payable and what input tax is deductible. So it wasn't appropriate in that case to aggregate a series of different transactions, although they were preordained and necessarily led to a position whereby the school ended up in practical use of the grounds. You couldn't simply default to a global picture. You had to step back and say, well, what was the particular interest which the school derived answer from the license? That license was not from the school itself, and therefore it was a separate interest that was being relied on. So we say, with respect, that supports a construction of the self-supply charge in this case, which necessarily looks at the individual transaction position and doesn't look at certain separate transactions which necessarily form part of a preordained whole. Now, we do, with respect, therefore, say that the FTT fell into error in a number of material ways, and therefore, with the greatest respect, this court should not follow the urgings of my learned friends that you should simply reinstate the FTT's analysis. Firstly, it treated
the supply as a unitary whole, a commercial whole, even though there were separate supplies made by different taxpayers as part and parcel of the arrangements. Secondly, it placed emphasis on the commercial motivation for the transaction, even though in our submission that was legally irrelevant. Yes, it was part of the context. No, it couldn't drive the actual VAT classification of the specific circumstances. It then gave effect to a commercial unity approach that was derived from direct tax case law rather than VAT case law, and therefore ignored the transactional nature of VAT. And it ignored the direction of supply and the separate identity of the taxpayers in this case. There is a, if I may say so, there's a nagging question that must lie behind the single supply analysis if one is to accept it from the taxpayer in this case. Whose supply is it? And what is the supply? And what's the VAT classification of it? The VAT classification may be straightforward if it's all exempt, and it's exempt either way. But the direction of supply and the nature of the supply is exceptionally difficult. Is it being said?
We're not here concerned, are we, with identifying within a transaction by the party of the supply, but with identifying circumstances in which a fictitious deemed self-supply is, by virtue of statutory make-believe, deemed to have occurred. And in principle, Parliament could specify any concatenation of circumstances which triggered that deemed supply, whether they were separately supplies or not.
But as your Lordship found in the Fowler case, the deeming provision, whilst it is a fiction, it's a statutory fiction and therefore represents reality. So
well, this one doesn't.
But
this can only be, there's no reality in a self-supply. It's just a convenient way of achieving a certain fiscal result.
The fiscal result it achieves here is to constrict the ambit of the zero rating benefit that's conferred at the prior stage.
Yes, right.
And so it's putting the brakes on the ability of the taxpayer to continue to benefit from the largesse of a zero rating transaction.
Indeed, but even if you put it, the self-supply as being a convenient way to undo an earlier zero rating, which I can see that arithmetically it may be, even if you put it that way, Parliament can specify any concatenation of circumstances not themselves amounting to a supply, which, if they occur within a certain period, cause the previous zero rating to be undone and unwound.
Yes, Parliament simply could have said, if these are the circumstances, you will pay a charge.
Exactly. So, but I'm just questioning your assumption that this is all about identifying by reference to the parties' use of contractual provisions a supply, and saying it can't possibly, the conditions for the applicability of this subparagraph can't have anything to do with benefits moving in opposite directions.
Well, because the analysis, the structure that Parliament in fact chose was not simply to say, if you do this, then you will pay X. Parliament chose to use a system whereby they referred back consciously to a prior zero rated transaction, and then examine the circumstances and whether or not the underlying conditions for zero rating that transaction continued to be met over a period of time. And so we end up with a position whereby if you simply got rid of the asset that is zero rated, say we're dealing with English property law, say it's a freehold interest, if you've sold the freehold, Parliament has deemed that you no longer benefit from the zero rating provisions.
Well, I can quite see Parliament could have said that. But that would assume that its interest in the property within subparagraph 2 can only mean the precise interest which is acquired under the zero rating transaction. So I think you have to say. For example, I think you would say that if the first grant was of a long lease and then P bought the freehold and then sold the lease, he would have disposed of his interest because he sold the lease even if he retained the freehold.
Well, he would have obtained the reversionary interest as a separate transaction.
Yes.
The answer,
it wouldn't be the zero rated transaction. It should be an exempt transaction.
yes.
Yes.
So the issue there for zero rating purposes would be solely in the leasehold interest that my lords identified.
Yeah. So you have to construe its interest in the property in subparagraph 2 as meaning that very same interest which is acquired by the zero rated transaction.
Yes.
But where do you? I mean, how do you do that?
Well, I'll come on to the mechanics by which Parliament has chosen to cross-refer back, but in essence, it's because of the definitions chosen by Parliament to define entire interest, which in context must necessarily mean the zero rating in question.
Well, I'll wait with anticipation.
Yes. Now, that's what I wanted to say on the overall principles of VAT. The principles, I think, in relation to zero rating can be more shortly summarised. We've referred, in our case to the Marks and Spencer's case, which does deal with the scope of zero rating. I anticipate that a number of propositions I derive from that case are relatively uncontroversial. Could I please pick it up? It was one of the infamous cupcake cases about treatment of chocolate-covered cupcakes, which took various guises through the courts over the years. It starts at page 1993, please. One sees the factual background set out. In a nutshell, there was a claim for overpaid VAT. That went through various permutations, including a reference to the CJEU. The question then arose, was there a directly effective right under EU law not to pay, or rather to be able to pay VAT at the zero rate rather than the standard rate? And the corollary of the question was, even if it wasn't a direct EU law entitlement, because it was a derogation permitted by EU law and therefore a feature of national law, nonetheless, did general principles of EU law apply, so that a claim for recovery of the proper rate of VAT could be sustained by reference to general principles. That can be seen at page 1995, with the specific questions referred by the House of Lords to the CJEU. Now, the court's reply, paragraphs 22 to 24, dealt with a number of general points on zero rating. We can see that, please, at page 1999. One sees, as my learned friend took you to Article 110 of the Principal VAT Directive that recognises the ability to retain these provisions. The court recognised, however, that in authorising member states to apply exemptions with refund of the tax paid, what was the predecessor to Article 110 lays down a derogation to the rules which govern the standard rate of VAT. It's therefore correct to state that it's by reason of community law that those exemptions known as zero rating are permitted. It then says, paragraph 23, however, community law does not require member states to maintain those. And it recognises that part of the function of the Sixth VAT Directive was to harmonise the overall approach, and that this was a derogation from that. However, as a result of changes to the legislation in 1991, the EU required that any exemption with refund could only be established for clearly defined social purposes and for the benefit of the final consumer. Then recognises in Article 24 that those provisions permitting that exemption with refund are a standstill clause. And what that means is once a member state chooses to remove the benefit of zero rating from a particular area of commerce, that's it. It's on a ratchet. You can't then reconfer the benefit of zero rating, because the idea is to achieve harmonisation. And at some point, when the member states finally agree on it, they'll do away with zero rating altogether. So that was the overall context. We then see at paragraph 28 that there was no directly effective right to zero rating as a matter of EU law. But nonetheless, at paragraphs 33 to 34, page 2002 to 2003, because this fell within the scope of EU law, taxpayers could rely on general principles such as, for example, fiscal neutrality, non-discrimination, which is a feature of it, legal certainty, and so on, to maintain their right to recover the overpayment of tax that they had suffered through the mischaracterisation of tea cakes. So EU law does imply, it does necessarily have a bearing on the scope of zero rating, even though zero rating itself technically is not a product of the EU it's a permitted retention. And that, we say, means that there is an emphasis on construing zero rating strictly, whilst recognising that that doesn't mean you can deprive the benefit of zero rating of its natural course. It means, if I can put it this way, there would be a tendency by the Court of Justice to give it a narrower rather than a broader meaning, all other things being equal. That brings me to the introduction of the changes to the rules governing the self-supply charge in 2011. I'm seeing that it's 2 minutes to 4. I'm happy to take your lordships and your ladyship to the statutory instrument that does that and the explanatory memorandum. It's a relatively short point, but it may take me 2 minutes 30 seconds, or I can leave it until the morning.
Well, if you need an extra 30 seconds, you can have them. Thank you very much, Mr. Bill.
Thank you. So the relevant statutory instrument is at page 1072. This is the 2011 order. And what it does at page 1073 is to say what you're going to cite this order as, which is the Value-Added Tax Buildings and Land Order 2011. We then see at page 1075, Article 8 of this order has effect in relation to buildings that are completed after the 1st of March 2011, which this building was. And then paragraph 8 at page 1081 introduces wholesale the paragraphs 35 to 37 that you've seen already and that I'll return to tomorrow morning. We then see at page 1085 the explanatory memorandum to the accompanying statutory instrument, which is an admissible source for construction of statute. And one sees that at the bottom of the page, under the previous provisions, the charge to tax and the method of calculation differed depending on whether or not the recipient subsequently granted an interest to a third party, where a change in use occurred in an unidentifiable part of the premises, the charge arose on the entire premises or part of the premises. Article 3, it says, substitutes new paragraphs 35 to 37. The new paragraphs provide for a uniform application of the charge to VAT and a single method for its calculation as follows, and then sets out what that method of calculation is. And at the top of page 1086, paragraph 36.2 provides that there is a charge to VAT where a person disposes of the entire interest in the premises or in a part of the premises. And paragraph 36.3, in contradistinction, deals with an identifiable area of the premises or part thereof which changes its use or becomes used for a non-relevant purpose. There's then a reference to paragraph 37 providing the formula as to how the supply is to be valued. That is what was identified as the rationale for the introduction of these changes. So the rationale for the introduction of the provisions dealing with disposal of the entire interest is set out there. It was to provide, and I quote, a uniform application of the charge to VAT and a single method for calculation. That doesn't put a great deal more flesh on the bones, but it does at least confirm that Parliament did intend to make separate provision for a disposal of the entire interest. My lords, my lady, I think that's where I should draw stumps given the time, unless you have any questions for me.
I don't see any questions being asked, Mr. Beale. Thank you very much. We will look forward to your continued submissions tomorrow morning at 10:30. The court will now adjourn.
Thank you.